33 is that evidence was put to Mr. Gaisford, and he was asked whether such a covenant would be enough to satisfy an independent lender, to which his answer was, no, I don't think it would. And again, there's no dispute that that was his evidence in cross-examination either. And then at 34, the error is said to be because the experts understood the covenant which they were envisaging in different terms, it couldn't be said that they were agreed. And LLC 5's position is it's fair to say the experts, at some parts in their evidence, definitely did have different covenants in mind, at least in relation to the payment of dividends on the preference shares. And Mr. Gaisford's envisaged covenant was certainly harder edged. However, both agreed in the joint statement that whatever covenants they had intended to refer to would be forthcoming. And Mr. Gaisford certainly confirmed that position in his own cross-examination. And so therefore it doesn't really matter.
Sorry, just to clarify, I think are you simply saying that, I think you said it was subject to caveats, but presumably you say not relevant. Mr. Gaisford confirmed the joint statement.
He did.
And you don't need to go further. Is that the essence of the point?
So Mr. Gaisford's caveat was the costly and complex point, which is that it would have been a commercially rational for someone else to do it.
You said two caveats, but was it just...
I don't think we have to worry about the other one, because the other one is the his own interpretation of what arm's length provision meant, i.e. he was, again, trespassing on another area of law. Don't have to worry about that. You could summarise it as this. Mr. Ashley had in mind a red covenant, and Mr. Gaisford had in mind a blue covenant. And Mr. Ashley's evidence was the red covenant is going to be forthcoming, and Mr. Gaisford's evidence is the blue covenant is going to be forthcoming. So, and the criticism of the revenue says, well, they hadn't agreed as to the colour of the covenant. What we'll come on to see is what the Upper Tribunal said is it doesn't matter. On their own internal view, they were both agreed that whatever covenant they themselves envisaged or had meant to refer to in the joint statement would be forthcoming. Doesn't matter that they hadn't internally agreed as to the exact nature of that covenant. And so the FTT was well entitled to conclude the covenants would have been provided in the hypothetical transaction. And what I want to do is take you to the Upper Tribunal decision which summarises that point. So if we just take up the core bundle, the relevant passage of the UT, I think, really starts at paragraph 82. So the UT is behind tab 6, and what we want to do is go to page 107. So paragraph 81, you have Mr. Prosser's submission, and then at 82 you have the Upper Tribunal's reasoning. And in particular, I'd ask you to highlight on the fourth line, even if there was a difference in the way the experts viewed the crucial covenant, ensuring that preference dividends were paid, the FTT was entitled to decide that all the covenants would be forthcoming at arm's length. We agree we accept Mr. Prosser's submissions. The FTT's findings in relation to which covenants would have been required were supported by the evidence and its own findings. And then if you go on, 85, in summary, the experts agreed that whatever covenants and other enhancements would have been required by an independent lender, that probably could have been achieved. And then at 86, you can see reference to the confirmation and cross-examination, which I've taken you to. And in relation to the costly and complex point, there's 2 points really on that. The first is that there was just a clear preference by the FTT for the evidence of Mr. Ashley, so finding a fact. Secondly, and in any event, that costly and complex point isn't really a question of evidence as between, for the FTT to determine on a hypothetical transaction. What it's ultimately doing is saying you're actually asking the wrong question. Mr. Gaisford, again, straying from his role as an expert on the questions that he was asked to address and say, actually, what we have to do is not look at LLC5 borrowing, but rather some other entity in the BlackRock group. Now, incidentally, that was the ground for the revenue before the Upper Tribunal. That was their ground 2 in the Upper Tribunal. And this point, which I'm now addressing, was their ground 3. There has been no appeal on the ground 2.
Okay, so you've, just to make sure I've understood.
Of course.
You're saying that what Mr. Gaisford was really getting at with the costly income complex was postulating a different transaction altogether involving different parties, rather than focusing on this transaction.
He was. It's slightly blurred in the evidence. He came up with a list of 4 factors, but ultimately, when pressed, he said he didn't really have any expertise on them, and he couldn't say for sure whether anything would, in the actual transaction, have been a deal breaker. And then he developed this other argument about it being commercially rational for some other entity to borrow. There was certainly a blurring in the evidence, but insofar as there was evidence, the expert evidence of Mr. Ashley was preferred. Clear finding by the FTT there.
Is that recorded in terms in the FTT?
It is. So if you go to paragraph 102, and this is page 192 of the core bundle. On balance, given that Mr. Gaisford accepted that his concerns in relation to cost and complexity did not amount to deal breakers, that's that passage I showed you in the transcript, I prefer the evidence of Mr. Ashley that the covenants would have been forthcoming. Similarly, and this is the point about parental support, we don't have to go into that, but there was a definite preference for Mr. Ashley's evidence on both those matters. And then, if I may, come on to just address or just point you to the Upper Tribunal's findings on what was termed ground 2 before it. That follows the discussion. Yes, grounds 2, 4 and 5 are addressed at paragraph 89, so starting at page 108 of the bundle. And if I can just invite you to read paragraph 90, which summarises the revenues ground, second ground 2 of appeal. And that then, if you then move on to 92, the Upper Tribunal deals with both ground 2 and ground 4. Both of these grounds of appeal suffer from the same problem that Mr. Prosso QC identified. Transfer pricing legislation is concerned with whether, and if so on what terms, an independent enterprise would have lent $4 billion to LLC5 and whether a company with LLC5's economic attributes would have been able to borrow the $4 billion, not with whether it was cheaper for the BlackRock group to borrow elsewhere. So that gets addressed. That isn't appealed as a point of law, but this point lingers in a challenge to the FTT's findings in relation to the evidence. A bit odd. What we don't have really is what the revenue's actual argument is, addressing what the Upper Tribunal has found in relation to the challenge on the evidence. If we go back to the revenue's skeleton argument, so their ground 1 discussion starts at paragraph 25 and ends at paragraph 37. But if one were to compare this passage of the skeleton with the skeleton before the Upper Tribunal, it is almost verbatim, apart from the introductory words of paragraph 25. But then if you map paragraph 26, that corresponds with paragraph 83 of the Upper Tribunal skeleton, and so on. And when I say verbatim, it is literally verbatim. Maybe mutatis mutandis, a few references. And then when one comes to 37, this is the only clue one has as to what the revenue's actual challenge to the Upper Tribunal's reasoning is. The UT stated, even if there was a difference, the FTT was entitled to decide that all the covenants would have been forthcoming at arm's length. And then the challenge is, but there was no agreement. that's not really engaging with the Upper Tribunal's reasoning at all. So in terms of these submissions, I've, as it were, tried to set the scene and introduce the issues, but the revenue skeleton gives a clue as to why they found the FTT's reasoning unsatisfactory. But we have no indication as to why the Upper Tribunal's rejection of their challenge why the Upper Tribunal erred in law in that respect. So I think that's all I can say until the revenue address you on that already.
Thank you, Mr. Yates.
Yes.
So may I now address the unallowable purpose issue? Could I take you to the bundle of authorities, tab 2, and it's page 19, 19 and 20, which set out sections 441 and 442 of the Corporation Tax Act 2009. So 441 on page 19 is headed Loan Relationships for Unallowable Purposes. This section applies if in any accounting period a loan relationship of a company has an unallowable purpose. The company may not bring into account for that period for the purpose of this part, and this part is the part to do with loan relationships with companies, so much of any credit in respect of exchange gains as on a just and reasonable apportionment is attributable to the unallowable purpose. Not worried about subsection 2, I shouldn't have read it out. 3, the company may not bring into account for that period for the purpose of this part so much of any debit in respect of that relationship as on a just and reasonable apportionment is attributable to the unallowable purpose. So if you find that the loan relationship has an unallowable purpose, and that'll be explained by section 442, you then have to ask how much of the debit is on a just and reasonable apportionment attributable to that unallowable purpose, and that much of it is then disallowed. I don't think I need to read the rest of section 441. Over the page, 442, meaning of unallowable purpose. For the purposes of section 441, a loan relationship of a company has an unallowable purpose in an accounting period if, at times during that period, the purposes for which the company, A, is a party to the loan relationship, or B, enters into transactions which are related transactions by reference to it. We're not interested in B, we're only interested in being a party to the relationship. Include a purpose, the unallowable purpose, which is not amongst the business or other commercial purposes of the company. And then 2, if a company is not within the charge to corporation tax in respect of a part of its activities, for the purposes of this section, the business and other commercial purposes of the company do not include the purposes of that part. 3, subsection 4 applies if a tax avoidance purpose is one of the purposes for which a company is a party to the loan relationship. Again, ignore B. 4, for the purposes of subsection 1, the tax avoidance purpose is only regarded as a business or other commercial purpose of the company if it's not the main purpose for which the company is a party, or one of the main purposes. And then 5, the reference to a tax avoidance purpose references to a purpose which consists of securing a tax advantage for the company or any other person. And then tax advantage is defined in section 1139 on page 26. We don't have to go there. That includes being able to get a tax deduction. So, I would like to make 4 submissions, brief submissions, on the interpretation of section 442(1), so the meaning of unallowable purpose. And my first submission is that the purposes referred to in 442(1) are the subjective purposes of the company. Now, I would submit this is clear from the language used at the end of subsection 1, a purpose which is not amongst the business or other commercial purposes of the company.
Well, is it the leading, possibly the purposes for which the company, you have to look at the purposes for which the company is.
The purposes for which the company is a party, but that makes it clear, I would submit, that you're focusing on the purposes of the company. But then it actually talks about...
Doesn't seem very clear to me, Mr.
Well, then I'll rephrase it and say I focus particularly on the ending of subsection 1, which in my submission is asking whether the purposes for which the company is a party include a purpose which is not amongst the business or other commercial purposes of the company. So that you're asking whether the purpose for which the company is a party are included amongst the business or other commercial purposes of the company. So in my submission, the focus must be on the purposes of the company. Now, you may not accept that, but
I don't see that it logically follows. I know you're going to show us some authority, but
yeah.
I don't see that just looking at the wording it logically follows.
Okay.
A transaction may have a number of purposes, and the opening words ask, does the loan relationship have a purpose? Yeah. And what it's saying on the face of it is, purposes are unallowable purposes if they're purposes which aren't commercial purposes of the company. But that doesn't mean that the only purposes you look at are the purposes of the company.
It doesn't logically follow. I would nevertheless submit that that is what it means. That
why does it not then say a loan relationship has an unallowable purpose if the company's purpose of entering the transaction are any other than its commercial business purposes? That's what you want it to mean.
That's what I want it to mean.
But quite strikingly, it doesn't say that.
Well, it's true, it doesn't say that. I accept that. I'm now going to go to authority.
Yes.
Which is Court of Appeal authority.
Yes, well, no, I understand there is authority, but I'm simply saying as a matter of language.
I accept that, and that is why my reliance on authority is important.
Yes.
And this has been the subject of debate in other cases. There's another case which will be before this court, apparently in a couple of months' time called JTI Acquisitions. And I'll take you to it. Obviously, I won't be submitting what's said there is wrong, because that would be preempting what the court might say. But in that other case, the Upper Tribunal do say, based on this wording, and without mentioning the authority I'm going to take you to, or at least not in relation to this point, that you can look beyond the purposes of the company. Now, my submission would be that that is wrong, based upon this authority, which is, I'll take you to now, Travel Document Service.
So we have the Upper Tribunal for JTI in the bundles.
We do, and I will take you to that passage, but I'm just sort of making the point that I suppose one might want to be careful about saying it's wrong if it's going to be heard by another Court of Appeal shortly. But I mean, that's a matter of etiquette for you, perhaps, I don't know. In any event, tab 12 of the authorities bundle is, so it's this same physical bundle, tab 12, is Travel Document Service. And at paragraph 41, this is in the judgment of Lord Justice Nugee, and at the very end, Lord Justice Bean and Lady Justice Arden agree. So I think one can take it as the court agreeing with what's said at paragraph 41.
Before we do that, could you just give us a brief summary of what all this was about, and so that we can have the context?
Yes.
So
it's quite complicated, unfortunately. Because
well, I was hoping you were going to be able to make this simple, because I've tried. Yes.
Right, okay. I'll do my best. So it wasn't about an actual loan relationship, first of all. It was about a tax scheme which involved using some shares in the company. And because of the circumstances attaching to those shares, the holding of them was deemed for tax purposes to be a loan relationship. And so these particular shares had been acquired in the first place by the company for perfectly good commercial reasons. But then they were used as part of a tax scheme to get a tax advantage. That was all common ground. and it involved devaluing the shares so as to get a massive deduction on the basis of a loss on the deemed loan relationship. So it was devaluing the shares and then claiming a loss. And the question was, in terms of the loan relationship legislation, why was the company party to the loan relationship, the deemed loan relationship, in the accounting period? And that was rephrased as, why did the company hold the shares at that time in the accounting period? We knew why the company had acquired the shares in the first place, for good commercial reasons. But why was it holding the shares? For what purpose was it holding the shares when it was doing the scheme? And the FTT had held that the purpose was a tax purpose. Now that was I think that's a reasonable summary of what the case was about. There was a debate.
This is under the predecessor provision.
Yes, it was, absolutely. It was the provision that my Lord has obviously looked
Got
at.
there.
Yeah. Para 13. But it's not materially different to the current legislation. Now, there was a debate around the fact that, first of all, evidence was given by one of the directors of the company, and no one thought that one shouldn't look at his evidence. No one said that one should look outside his position as a director of the company, as it were, to determine the purposes of the company. I'll come back to that.
So we're talking here, when you're talking about the purposes of a company, we're talking about a company that had been extant throughout.
Yes.
We're not talking about a company that's just sort of
No.
arrived, as has happened
Absolutely
in this
not.
case.
No. But
So that, I mean, you're
that's
going to have
factually
to,
different.
Yeah.
I
You're going to
accept-
have to deal with the conceptual difference.
Yes, absolutely. But in any event, so there was clearly no debate around why the company was created. No one asked that question, absolutely. So the director that I mentioned, Mr. Taylor, he gave evidence and said, we were holding the shares for the same reasons that we'd always held the shares, which is for commercial reasons. And that was reconciled with the fact that the FTT held, and the Court of Appeal agreed, that the purpose for which the shares were being held in that accounting period was a tax purpose. And it was explained on the basis that Mr. Taylor had a different meaning for why the purpose for which, Turner, I apologise, Mr. Turner. Mr. Turner had a different meaning for what purpose were the shares being held than the statutory meaning. But in any event, everyone was focusing on his purposes because he was the director of the company.
So his commercial reason was to get a tax break.
His commercial reason was because this was a subsidiary that we wanted to carry on holding. That was the evidence that he gave. What was said was, so that wasn't the difference kind of thing, that wasn't the difference in the point. It was that he was addressing a different purpose of why you continue to own the shares rather than why you are putting them to a particular use. So what was said was, your purpose for holding the shares, and therefore your purpose for being a party to the deemed loan relationship, extends beyond ownership to what use you're making of the shares. He was simply addressing why we still owned the shares, and wasn't addressing why you were making use of them.
Well, the deemed loan relationship was presumably the combination of the shares and the transactions that were done to create this devaluation. And is the point that you're looking at the purpose of that?
No, that was a finding by the FTT, I think. And the Court of Appeal said, no, you're not, and I'll take you to that. The Court of Appeal said, you've got to focus on the particular question, why are you a party of the loan relationship, and therefore why are you holding the shares, not why have you entered into the wider transaction.
But it's specifically holding the shares
Yep.
rather than the shares in combination with the other.
Yes, it was why are you holding the shares, which includes or can be understood by reference to what use are you making of the shares. Well, obviously this is all in the deemed world of the shares being a loan relationship, but I wanted to take you to paragraph 41. So 40 says, I think it's clear from various paragraphs of the FTT's decision that the FTT found that TDS had an unallowable purpose for holding the shares, and hence being part of the loan relationship that was deemed to exist. Was it justified in arriving at that conclusion? So this is 41. The following points bear, as it seems to me, on when a company should be considered to have held shares for an unallowable purpose. 1. A company had an unallowable purpose if its purposes included one that wasn't amongst the business or other commercial purposes of the company. Now, immediately, one sees that Lord Justice Nugee has talked about a company having an unallowable purpose if its purposes included one. So that when my Lord Justice Nugee said, well, but surely the starting point is the purposes for which the company is a party, I would suggest that Lord Justice Nugee is looking at the legislation and saying that this is focusing on the purposes of the company. And then two...
Can I be clear?
Yeah.
In this case, the FTT concluded that the company, TDS, did have an unallowable purpose.
Yeah.
What Lord Justice Nugee is addressing is whether they were entitled to reach that conclusion. Clearly, if the company has an unallowable purpose, you have to ask what the purposes of the company are, if that's the question. Does not seem to me to follow that that's the only question you can ask on the wording of the legislation, which is whether the loan relationship has an unallowable purpose, which can involve asking the question, why is the company a party to this loan? And I would have thought the answer to the question why the company is a party to the loan is not limited to what was the company's purpose in becoming a party to the loan, but can involve a wider question of why is the company in this world at all?
Well, can I...
in other words,
I understand that.
You understand the point, but what I was pushing back on was the suggestion that because the way Lord Justice Nugee is answering the question in that case, where what he is doing is deciding whether the FTT was justified in reaching the conclusion that the company had an unallowable purpose, it doesn't seem to me to follow.
So it won't go
that's
back.
the only question you can ask.
Right. Paragraph 39 begins by, the question to be answered was whether the purposes for which TDS held shares included an unallowable purpose. And I accept that then the focus is on the finding of the FTT, that the answer was yes, because of the company's purpose. I accept that. But then, so just reading on anyway, paragraph 41. A company had an unallowable purpose if its purposes included one that wasn't amongst the business or other commercial purposes of the company. And then a tax avoidance purpose wasn't necessarily fatal. 3, it was the company's subjective purposes that mattered. Brebner considered a comparable issue is whether transactions had as their main object, one of the main objects to enable tax advantages to be obtained. Lord Pearce concluded that the object which has to be considered is a subjective matter of intention. And Lord Upjohn and with whom Lord Reed agreed, said the question whether one of the main objects is to obtain a tax advantage is subjective, that is a matter of the intention of the parties. 4, when determining what the company's purposes were, it can be relevant to look at what use was made of the shares. What you do with an asset may be evidence of your purpose in holding it, but it need not be determinative of that purpose. The benefits you hope to derive as a result of holding an asset may also evidence your purpose in holding it. So I accept that my reliance on what Lord Justice Nugee said perhaps is misplaced in the context of the question that was actually before him, which is whether the FTT were justified in identifying the question by reference to the purposes of the company. But I nevertheless submit that that is what Section 441 is interested in, and I also accept that the language at the beginning suggests, by reference to the purposes for which the company is a party, might be asking a wider question. Perhaps in that context, I should take the court to Section 455B, which is also in the bundle.
To be clear, was inserted in 2000.
Yes, it was. Yep, I will make that point.
Sorry, inserted when?
So 2015.
Yeah.
This is in tab 3. Section 455B, counteracting effective avoidance arrangements. Any loan-related tax advantages that would, in the absence of this section, arise from relevant avoidance arrangements are to be counteracted by the making of such adjustments as are just and reasonable in relation to credits and debits, and so on. And then Section 455C over the page explains what relevant avoidance arrangements are. And so on page 22 at subsection 3, arrangements are relevant avoidance arrangements if their purpose, or one of their main purposes, is to enable a company to obtain a loan-related tax advantage. Now, if one's looking at competing ways of drafting a provision, it's very clear from this legislation that the focus is much wider than on the purposes of the company. So that when my Lord says, well, it could have been drafted differently, I could throw that point back and say, well, yes, but if the draftsman was wanting to make it clear that they were not simply interested in the purposes of the company, but were interested in wider purposes, like why was the company created, my submission is that there is another more clear way of doing that. And I'm clearly not relying on 455B as enforced at the relevant time. It's more a drafting point that I'm making.
What you can say is 455B and C show that you can have a rule, and there are plenty of examples, that focus on the purpose of arrangement.
Yeah.
441 and 442 have a different focus. They focus on the purposes, I think this must be coming on, the purposes for which the company is party to the relationship. And I think the question being put is whether that is, you have to read that as confined to the effectively borrower's subjective purpose, or whether it connotes something wider, albeit that it's not saying the same as the overall arrangement.
No.
So there is, you can still see a distinction.
Right.
That doesn't necessarily confine it to the subjective purpose of the directors of LLC.
Well, I suppose the first question is, are you focusing on the purposes of the company?
Yeah.
And if you are, then I would submit what Lord Justice Nugee said about it's the subjective purposes that matter, flows from that.
I think that's probably right. I mean, I don't have any difficulty with the proposition. Purpose requires looking at why somebody did something.
Yep.
If the question is why the company did something,
Yep.
the company can only act through human agents. That means the board of directors or other organ of, and you have to ask, why did they do it?
Yep.
And you are undoubtedly going to look at what was in their mind.
Right.
But
just, can I just?
But I think that the question I have
understand your
is
point. Is that the right starting point?
Is it just confined to why the company did it, or is it a wider question of why was the company there?
Okay. Now, the point I wanted to make about that is, when the Upper Tribunal made its decision, it focused on the purposes of the company.
Why the company did it?
Why the company did it, but said that is not confined. The answer to that question is not answered solely by reference, or shouldn't be a particular case, to the subjective purposes of the directors. In other words, the Upper Tribunal wasn't making the point which my Lord made to me, that I've misunderstood what Lord Justice Nugee said. He wasn't laying down a rule about 441 generally. He was focusing on purposes. And actually, you've got a wider focus on not just the purposes of the company, but the purposes for which the company is a party. The Upper Tribunal wasn't doing that.
That wasn't the point.
No, that wasn't the point. So that might be a good point, but it wasn't the point on which the Upper Tribunal reversed the FTT's decision. I will take you to that. Anyway, you've got the point that if we are looking at the purposes of the company, then Travel Document Services suggests or lays down that it's the subjective purposes of the company that matter. And that is derived from cases admittedly on other legislation, but that, I would submit, is a very sensible approach to adopt because a company is a fiction, clearly. You've got the question of purpose is a subjective question. And so the next proposition is, well, if you're looking at a subjective purpose, whose purpose are you looking at in the case of a company? And I would submit that it is, as my Lord Justice Nugee mentioned, it is the directors of the company if they are the ones who are taking the decision on behalf of the company. So that clearly it would be different if the directors are acting merely as puppets or on instructions. And then you ask, well, who is really running this company? There's no evidence of that here. So that, in my submission, if you are focusing, as the Upper Tribunal accepted you should do, on the purposes of the company, then there would be no justification for moving away from the subjective purposes of the directors of that company who are taking the decision. And the reason, as we'll see, why the Upper Tribunal did move away from that is because they didn't like the result, effectively, that these directors had genuinely left tax out of account because the tax advantage couldn't benefit the company. And the Upper Tribunal thought, well, if you can do that, then you can undermine the legislation. I'll have an answer to that, but that was why the Upper Tribunal said you're justified in those circumstances in moving away from looking at the director's purposes to other people's purposes that can be attributed to the company. But it was still focusing on the purposes of the company. That's the point I'm making. Now, just going back to the first point about whose purposes is 441 looking at, can I take you to what the FTT said about that? This is at paragraph 109, first of all, where there's that reference to C 109 in relation to the identification of the purpose of a company. So, stopping there, the FTT is focusing on the purpose of a company and then referring to Travel Document Service. And then if you go to 115, under discussion, it's common ground that the deduction of loan relationship debits is a tax advantage. It's also common ground that it is the subjective purpose of LLC 5 that is to be considered in order to determine whether securing a tax advantage was the main purpose or one of the main purposes of its loan relationship with LLC 4. Now, so the point that Lord Justice Nugee pressed me with, which is that right that one should be focusing on the purposes of the company? That was common ground before the FTT, and HMRC did not appeal to the Upper Tribunal, suggesting that that was wrong. So that this whole case has been done on the basis that you are looking at the purposes of the company and its subjective purposes. So perhaps I was wrong in going immediately to Lord Justice Newley and saying there it is. But there it is in terms of what was the issue between the parties and what was common ground.
Yeah.
Now, I mentioned that, so that was the first point. We're looking at the subjective purposes of the company. Then if we go to 117 of the FTT decision, as a company is a legal construct, its intentions are, in the absence of evidence they're acting as a puppet, being usurped or bypassed in the decision-making process, those of its directors. In the present case, there's nothing to suggest that, despite their significant involvement in the creation and advice on the implementation of the transaction, LLC 5 ceded control to its advisors or other parts of the BlackRock Group. As necessary, as such, it's necessary to ascertain the subjective intentions and purposes of LLC 5's directors in respect of the transaction. And that, again, wasn't criticised. That wasn't said to be an error of law on the part of the FTT. And in saying at 117, as a matter of fact, so the second sentence, nothing to suggest that it ceded control, that's a finding of fact, that they weren't acting on instructions. There's a reference in various places of the FTT decision, paragraphs 52 and 119, that they were acting on advice. The advice was, don't take account of the tax advantage because it doesn't benefit the company in any way. But it's advice. It wasn't instructions which the directors felt compelled to comply with. Now, the reason I mention that is because when we get to the Upper Tribunal decision, the Upper Tribunal says that these directors they were circumscribed. They weren't free to make their own decision. And my submission is there's simply no evidence for that. Just acting on advice does not mean you are circumscribed and are not free to make your own decision.
Well, they were acting as part of a concerted plan, which they were the authors, in part.
True, but the evidence was, which the FTT accepted, that when Mr. Cushell, who was one of the authors of the plan, sat down with the other directors, that he was specifically wearing his LLC 5 hat, and he was thinking about it from the point of view of the interests of that company. Now, that was his evidence, which was accepted by the FTT. Now, if my lord had been the advocate in that case, you might have said to Mr. Cushell, come off it. You were simply carrying on with the plan that you were the author of. You didn't simply wear your LLC 5 hat and focus on the benefits to LLC 5. In reality, you were giving effect to the plan. But Mr. Ewart did not cross-examine Mr. Cushell in that way or in any other similar way. He did not challenge his evidence that he was focusing on, and the other board members, the FTT found, were focusing on the interests, the commercial interests of LLC 5. Now, it's because of the way that the case went before the FTT, the nature of the challenge to the directors and to the board minutes, which were accepted as being accurate, and the findings of the FTT in the light of that it's simply not open. And the Upper Tribunal didn't do this. The Upper Tribunal was perfectly fair. It didn't say, come off it, this was all part of a plan. It accepted and recorded the fact that Mr. Ewart didn't challenge Mr. Cushell on that, or the veracity of the board minutes. And in those circumstances, the Upper Tribunal didn't, as it were, venture into being a new cross-examiner on behalf of HMRC. So however unhappy one might be about the acceptance of that
I wasn't
evidence.
expressing any
a
degree of unhappiness.
I wasn't putting that to you.
I'm just observing what's obvious.
Yeah. It was obvious, but nevertheless there are findings of fact about the decision-making processes of the board.
Can I, there's a point that's troubling me, which is one can accept the evidence of the members of the board that they put on a particular hat when they sat down to say, do we do this? And that particular hat they were wearing was LLC 5. They need to be satisfied that it is in LLC 5's commercial interests to to issue 4 billion of loans in return for getting the assets they get, and so on and so forth. You can understand all that, and that you can accept all that evidence without impugning anybody's veracity or saying that it's artificial or anything else. And yet you can still, can't you, envisage that the directors, even though, as you've said, and you'll probably come back to, LLC 5 doesn't get a tax advantage because it doesn't have any profits to set against the losses, and the losses are going to be surrendered to other group companies without payment. Can it not still be part of the reason they do it, that it's A, in the interest of LLC 5, and B, generates tax advantages for other members of a group?
Well,
I mean, that's a perfectly proper thing for a director properly acting to take into account, isn't it?
well, it's a perfectly proper thing to have found as a fact, based on the evidence.
Your point is that wasn't...
Yes, that wasn't found.
That's not the factual finding.
Yeah. And it may be that one would say, well, why on earth not? The answer is because of the way that the challenge was put. That it simply wasn't suggested that that was in the minds of the directors as one of their reasons for doing it. Yes, of course, you've decided it's in your interests. Aren't you doing it for a further reason as well, that it's in the group's interest? That wasn't suggested for Mr. Couchel as being, and indeed the evidence which the facts which the FTT found was specifically that Mr. Couchel and the board minutes suggested, the other directors as well, put out of their minds in making their decision that tax advantage. So in my submission, again, one might say, well, one would have challenged that proposition before the FTT, but that's what the FTT found, that they put that out of their minds. And so in my submission, that is an express finding that they didn't take it into account for the benefit of the group. I would suggest this is one of those cases where one might be very surprised by the findings of fact, but when I explain how the FTT got there in terms of what was being challenged and what wasn't, it's just a case where one has to accept those findings.
Yep. Thank you.
So I've made the point about the findings of fact that the directors were acting on advice rather than on instructions. And I'll come on to the point where the Upper Tribunal said they were circumscribed. But in any event, it's never been part of HMRC's case that the decision was taken by someone other than the directors, or that they weren't willing in their decision making, or that they were circumscribed. That was never part of HMRC's case. So that when at 117, last sentence, the FTT say, as such, it's necessary to ascertain the subjective intention and purpose of LLC's directors, in my submission, that's absolutely right, no challenge to that. And then we come on to what, in fact, the FTT found about their subjective purposes and intentions. Now, and obviously I'll take you to that, but my next submission on interpretation, and I've sort of gone off interpretation slightly into the facts, but in any event, my next submission on interpretation is what the FTT said about inevitable and inextricable consequences being linked to purposes. And this is...
Sorry, I'm just keeping my notes in order. You had subjective purposes of the company as point 1.
Yes.
Are we moving to point 2?
Well,
Or just so I can keep a note of where we are in this.
I've moved around rather a lot. So my first point is it's the subjective purposes of the company.
Yeah.
My second point is, given that the company is a legal fiction, that means the subjective purposes of whoever takes the decision for the company, which in this case is the managers, board managers, the directors. And then my third submission is what the FTT said about inevitable and inextricable consequences, and my submission is how that can apply, or I would submit doesn't, in the context of this legislation.
So as to that third point, was there a reference that I haven't?
We haven't. I haven't taken you to it yet.
We haven't got there yet. Okay.
I'm going to go there. So actually, we have to go back to 112.
Thank you.
when the FTT say when identifying a subjective purpose, it's clear from Mallew and Drummond that this can be wider than the conscious motive of the person concerned. And then there's a reference to what Lord Brightman said. Could I ask you to read what Lord Brightman says, so I won't have to take you to Mallew and Drummond itself? Sorry, can I just explain what Mallew and Drummond was about? It was about Baroness Mallew, a barrister, who claimed a deduction for the costs of her black clothing for court, for work and court. She gave evidence, which was accepted, that when she decided to buy those clothes and bought them,
She wouldn't have bought black clothes for any other reason. She only bought them because her profession required her to.
yes, absolutely. And she said, she gave evidence that all she had in her mind was the requirements of work in buying those clothes. Nevertheless, the general commissioners of the Middle Temple held that one of her purposes, her subjective purposes, was a non-tax purpose, and therefore the expenditure wasn't incurred wholly and exclusively for her profession, being the purpose of being warm and decent. And the question was, how could that be reconciled with the test being a subjective one, which is coming round it was. So in the High Court and the Court of Appeal, it was decided, well, given that the evidence was accepted, that all that was in her mind was the needs of work, it must be that her sole purpose was a work one. In the House of Lords, Lord Millett, then counsel, said, well, you don't just look, as a matter of common sense, at conscious subjective purposes. You also look at sub or unconscious motives. And the way I would respectfully put it is this, that if you asked Baroness Mallew to articulate her reasoning, why am I buying this clothing? She may have jumped consciously for work, but logically, the starting place is I need clothes at all for warmth and decency. I need black clothes for my work. Therefore, I'm going to buy black clothes. And therefore,
She was answering a different question, which is why are you buying black clothes
yes,
rather than purple clothes?
yes,
Because
exactly.
my work requires, but she should have been asked the question, why are you buying clothes at all?
Yes.
To which there's only one obvious
Exactly.
answer.
Well, that's the short point. So that's the answer to her point, as it were, that all that was in her mind was I need them for work. The answer which my Lord has just given can be, as it were, spelled out from her behaviour, even if it wasn't consciously in her mind. Maybe you could ask her the question, and then she would have to say, well, of course, I accept. I need them to be warm and decent. The mere fact that that didn't cross her mind consciously when she took the decision is neither here nor there. So
And
that's
it explains why she could get a deduction for her bands.
Yes.
Because
Yeah.
they have no purpose other
Exactly.
than...
Yeah. Well, maybe none, but in any event, certainly no private purpose. Now, basically, my submission is that when the FTT applied that approach to this case and said it was inevitable that if you borrow money at interest, you will get a deduction, that inevitable consequence must be one of the purposes, the subjective purposes, even not conscious ones, of the directors. That was the FTT's reasoning, applying Mallew and Drummond. Simply by the fact that the consequence is inevitable. Now, my submission is it's all very well applying that Mallew and Drummond approach in a sort of common sense situation to do with warmth and decency, for example. Another example of it is a case called McKinley.
That's the curtains and carpets.
That's the curtains and carpets. And that was a case where partners were reimbursed expenses of moving house to be in a more convenient house for work. And the question was whether the curtains and carpets were deductible as being wholly and exclusively incurred for the purposes of the profession. And in the House of Lords, Mallew and Drummond was applied and said no. And I would submit exactly the same reasoning applies. If you ask, why do you need curtains and carpets at all? That's to do with furnishing your home. It's a private purpose. Why do you need new curtains and carpets? Well, because you're moving house for work, but why you need them at all is a private matter. So that's why it's not wholly and exclusive for the purposes of the trade. Now, in a case called Vodafone, Lord Justice Millett then referred to those two cases, and although he said the question of purpose is subjective, and he quoted from Lord Brightman as saying that's different from consequences, including inevitable consequences. I'll come back to that in a moment. He then said some consequences are so inevitably and inextricably involved that they must be regarded as one of the purposes. Now, he was clearly referring there to the Malilou and Drummond and McKinley type case. If you apply that to, for example, this legislation, and you say, simply because borrowing money, the legislation says if you borrow money, you get a deduction. It cannot be the case that because that's an inevitable consequence of borrowing money, it must be one of the purposes, subjective purposes of the directors of the company in borrowing. It can't follow, because then you'd never get a deduction, unless it's not important. But in many cases, it would be important if it's a very large deduction in amount. So my submission is that that Malilou and Drummond approach is perfectly applicable in a sort of common sense area where one says, your reasoning in spending this money implicitly includes a private purpose. Not consciously, but logically it does, because you've jumped to why black, and rather than consciously asking why clothes at all. But that sort of line has no application at all in this sort of context, because the directors haven't sort of jumped to the conscious question they're asking, why borrow this money, from some non-commercial purpose in the middle, as it were. It's simply not comparable. I mentioned...
well, I think you would presumably say this wasn't subconscious. They were consciously aware of it and put it out of their mind.
Absolutely.
I think
well,
that's what you...
That was the finding of fact. That was the finding. But the FTT nevertheless made that point, that they consciously put it out of their mind, but then said, nevertheless, a subjective purpose must be attributable to them applying Malilou and Drummond. In my submission, the Upper Tribunal was right in saying that was an error of law.
So, I mean, the conscious putting out of the mind was, and I mean no disrespect by this, but it was part of the concerted plan.
Well,
It had to be.
Yes, I accept that, but the question then is whether it was genuine. In other words, you can say...
Nobody's doubting the genuineness of the individuals involved in putting this plan into effect.
No, not the genuineness of the plan, but the genuineness of the statement that I've put it out of my mind. In other words...
Well, I mean, I very much appreciate your point about what findings were and were not made, or what cases were or were not put.
Not really cases, but what evidence, what
exactly.
Cross-examination was put.
Exactly, I fully understand that. But if one crosses an ocean in order to be somewhere that one doesn't really want to be anyhow, in order to get a tax advantage, it strains my reasoning to think that you then put it out of your mind.
Well,
when the whole reason you're there is to do just that.
Right. When you say the reason you're there, the first question is, why was the company created? And I would submit that the reason why the company was created cannot be an answer to what was one of the purposes of the directors. That it may be relevant, of course, when one is testing.
Well, nobody was able to give a reason, any other reason than tax reasons, why the company was created.
No, I'm not denying that. The point I'm making is the mere admitted fact that the company was created for a particular purpose does not tell you. It may be evidence of, but it doesn't necessarily tell you what were the subjective purposes of the directors of the company in taking a decision.
What the subjective purposes? I mean, I'm approaching this at the moment unburdened by everything that's happened so far, you understand, but I'm just trying to test your your general argument that the subjective purposes of the individuals who are responsibly involved in this process would involve one assuming that they knew what they were about and what was going on here, and that one wasn't expected to live in some looking-glass world where they just happened to turn up in a room.
No, they said that they weren't working in a vacuum.
Yes, they weren't working in a vacuum.
Yep.
And so, doesn't the contents of the atmosphere around them then shine? Mixing my metaphors, but doesn't it inform what their subjective purposes were?
I would submit, as a proposition of evidence, if I were before the tribunal and I were making a submission to the tribunal of what inferences they could properly draw as of findings of fact about what were the subjective purposes of the directors, I would be making those points. I would also be challenging the directors, maybe unsuccessfully, but in any event challenge them as to what they were actually doing, what they were all about. But I would be saying to the tribunal, get real. The reality here is they were acting in accordance with a plan, and you should find as a fact.
So you'd be making all the real-world arguments that you made this morning about this point. Right. But so I'm only asking you at the moment about whether conceptually and legally that isn't a perfectly reasonable way of approaching this legislation. But I'm not losing sight for a moment of the fact that you say, if you're right, you hear everything, that that's not how it was gone about here.
Right. Well, my submission is that one's got to ask, I would submit you, one's got to ask, first of all, whose purposes are you looking at? Then what is it meant by looking at the purposes of the company? And if it's right that you are looking at the purposes of the directors and their subjective purposes, then you have to rigorously apply that test. And it's no answer, and I'm not saying anything about what you're saying, it's no answer because you don't like the result of what the findings of fact that have been made based on that approach, to say, well, actually, maybe I shouldn't really be focusing on the subjective purposes of the directors. Maybe I should look more widely. This is what the Upper Tribunal say.
No, maybe I should look at what the subjective purposes of the directors really are.
Right, but that is an evidential point.
Exactly. But
that is a factual point.
So you've no difficulty with the conceptual.
Conceptually, none at all.
No, but so in a sense your argument here hangs on the fact that, I think you've told us, it wasn't the case that you had to meet.
Yes. Yes, I'm sorry. That is exactly really it. It wasn't the case that I had to meet because there was no challenge. That wasn't being suggested. And there were findings of fact about what were in the minds of the directors and therefore what their subjective intentions were that the Upper Tribunal that weren't challenged and the Upper Tribunal didn't set aside. So what I was addressing at the moment was the FTT's decision that there was nevertheless a subjective purpose of obtaining a tax advantage.
Mallew and Drummond.
Mallew and Drummond, which the Upper Tribunal said was wrong. I haven't taken you to the cases, and I'm very happy to do so. In one of the cases, in Mallew and Drummond, there's a discussion about an earlier example given by Lord Hoffman of a doctor or surgeon, I think it is, who goes down to the south of France to treat a friend of his. And he's enjoying his bottle of rosé or whatever on the balcony in the south of France. And the question is whether the expenses of going down there and coming back are deductible. And it said, well, that may be one of the consequences, the known consequences of going down to the south of France. You're going to have an enjoyable time with your friend. But the question is not what the consequences are, but what your purposes are. And the two don't necessarily hang together. They can be different. And that was repeated by Lord Brightman, that your purposes are not the same as the consequences, indeed
but
the inevitable
argument is that the consequences can sometimes shine light on the purpose.
Shine a light, absolutely. They're not the same, but they can shine a light. But that's not what the FTT said in this case. It didn't say that the consequences shone a light. It simply said, applying Mallew and Drummond, it's an inevitable consequence of borrowing the money that you get a deduction, and therefore that must have been a purpose. Perhaps I can take you to the...
120.
Yes, thank you.
So I'm sure you're going to deal with this in its right place, but let's suppose we're persuaded by that argument, namely that this is a faulty process of reasoning.
Yeah.
What's then the consequence for you on this issue? That it has to be done again properly?
No, the consequence is that if, as the Upper Tribunal said, the FTT erred in applying this Malalieu and Drummond approach, then we're left, in terms of subjective purposes of the directors, with a finding of fact that they had a commercial purpose, and no finding of fact that they had a tax purpose. Indeed, a finding of fact that they left tax out of account.
Can you please point us to those findings? 'Cause
I'm going to.
Yeah.
I'm sorry, and I was meaning to take you to some points of interpretation, and I've jumped around, and I apologise for that, but I will do that. But what we're left with then, if it's right that you shouldn't apply Malalieu and Drummond, is that we're left with what the Upper Tribunal did, which is to say we're going to move away from the subjective purposes of the directors in order to identify the purposes of the company.
But if they were, I think you're saying they were both wrong for different reasons.
Well, the FTT was wrong in applying Malalieu and Drummond.
And the UT was, you say, wrong to go wider than the narrow border,
Yeah.
as it were. So it's sort of sounding as if
It's all gone.
you'd have to do it again.
Well, no, because what we've still got unchallenged, unreversed, findings of fact, which I will take you to, of the FTT. One, that they did it with a commercial purpose, a subjective commercial purpose. Two, that they did not have a conscious subjective purpose of obtaining a tax advantage. So, based on those findings of fact, the only problem with what the FTT said is that there was that Malalieu and Drummond subjective purpose as well. Now, if we ditch that, and we decide that the Upper Tribunal was wrong in moving beyond the subjective purposes of the directors, then we're left with the actual findings of the FTT, that there was a commercial purpose and no subjective tax purpose. And that, therefore, leads inevitably to the conclusion that we haven't got an unallowable purpose. So that's why we're not just left up in the air with everything having gone wrong.
Right, so the argument is it doesn't have to be remitted because there's only one answer?
Well, there's only one answer based on the facts found, which is there was a commercial purpose and no subjective tax purpose. Those were the facts found. Everything else on the part of the FTT is Malalieu and Drummond, wrong. Upper Tribunal said that correctly. Two, the Upper Tribunal said move away from the subjective purposes of the directors to other purposes, wrong as well. So one's back to the findings of fact of the FTT about the subjective purposes of the directors, which is the right test to apply in identifying the purposes of the company. And the beginning point is, it was always common ground that that's, in applying 441, that's all you're interested in, the purposes of the company. What? No, and it's never been suggested even now that one should be adopting a different test of the purposes of the company. So I think on that basis I need to take you to the findings of the FTT, both on the commercial purpose and the no subjective, conscious subjective tax purpose point. Mr. Yates asked me to mention that one of HMRC's grounds on their respondent notice is the Malalieu point. So they're maintaining that it was right on the part of the FTT, despite the Upper Tribunal disagreeing, to apply Malalieu.
Right, and just before you go to the findings, I'd sort of got to point 3 on your list of 4, and I'm sure you've made point 4, but which was it? You know how we are with lists.
Yes. It's actually became, perhaps I should stick with 3, but, but I did want to address a point that I mentioned to Lady Justice Falk that I would, to do with focusing in travel document service, not on the purposes of the arrangements, but on the particular purposes for which the company held the shares. Could I just mention that was paragraphs 37 to 38 of travel document service?
So that addresses
Well,
arrangements versus.
it's a much narrower approach. Perhaps I can take you to that just to
Yeah,
be
thank you.
absolutely clear. So this is tab 12. And it's paragraphs 37 to 8. So really I can pick it up at 38. The FTT considered that the company's purposes in bringing about and maintaining the satisfaction of the conditions were what mattered. To my mind, that was a misconception. Paragraph 13 directed attention to the purposes for which the company was a party to the loan relationship. In a Section 91B case, that's the one where the shares are deemed to be a loan relationship. The relationship deemed to constitute such a relationship was that between an investing company and the company in which it held shares. It must be therefore correct to ask for what purposes the company was a party to that relationship, or in other words, for what purposes it held the relevant shares, rather than what the company's purposes were in bringing about and maintaining the satisfaction of the conditions. So I can turn to the findings of fact by the FTT. First of all, about tax purpose. If I can, and could I just make it clear that HMRC do not challenge any of these findings on Edwards and Bairstow grounds, as far as tax purpose goes. They did challenge, and they still do challenge, on Edwards and Bairstow grounds, the findings about a commercial purpose, but not tax purpose. So we've seen that in 117, the FTT saying it's necessary to determine the subjective purposes of the directors of LLC 5. And then if we can go to 118, in this regard, there's the contemporary documentary evidence contained in the minutes of the board meeting, as well as the evidence of Mr. Couchel in relation to that meeting. However, as he accepted, he couldn't speak on behalf of the other board members. Now, just stopping there, so we've got 2 things mentioned, Mr. Couchel's evidence and the board minutes. As far as Mr. Couchel's evidence goes, the FTT found him to be a reliable witness and accepted his evidence. This is at paragraph 5 of the FTT's decision. Found him to be a credible, truthful witness who at all times sought to assist the tribunal. And at paragraph 7, the tribunal had mentioned Guestmin and memories having faded and all that sort of thing, and said it's important to assess witness evidence in its proper place. That's what Guestmin said, and the tribunal said at paragraph, I think this is paragraph 9, taking that approach, as there is little between the parties in relation to the facts. So that's recognising that there wasn't actually a factual debate between the parties, and it was taking the approach that Guestmin said it should. In other words, it was evaluating his evidence. It wasn't just taking it at face value. It didn't disbelieve him. And as I say, there was little between the parties in relation to the facts because his evidence was not cross-examined in the sense of what he said was in his mind and so on was not challenged. Nor in relation to the board minutes. They were accepted as being an accurate record of what had happened at the meeting. Now, one has to jump around a bit in relation to what the FTT said because at various points it refers to Mr. Couchel's evidence it doesn't say it accepted the evidence. This is often, unfortunately, what tribunals do. They refer to evidence. But in any event, given that it has said he was a good witness kind of thing, I think it's reasonable to say that the only reason it's setting out his evidence is it's accepting it. So at paragraph 52, on page 174 of the bundle, although Mr. Crucial, sorry, 52. Although Mr. Crucial said there was a chance he would vote against LLC 5's proposed transaction at the meeting, he explained that having been involved in the step plan and various elements reviewing the transaction, he felt comfortable with it and no concern about its commercial viability. As such, unless one of the advisors during the presentation had brought out new information not previously circulated or consistent with his understanding of the transaction, this was unlikely. He also said he considered whether to proceed with the transaction without taking any UK tax advantage into account. And then though he couldn't now recall the details of the board meeting, he had no reason to think he would have acted contrary to Mr. Fleming's advice, as recorded in the minutes of the meeting, that, having noted that the company itself would gain no benefit from a UK tax deduction for the interest, as it was group policy for such interest to be surrendered for no payment, it was necessary for the transaction to be considered by the board and viable for the company without taking any UK tax advantage into account. So he's giving evidence that he followed that advice. And then 53, if the anticipated tax benefits had fallen away, it would have been too late to revise the structure and the acquisition would have gone ahead as planned. So that's 52. And then if we jump to 119, so that's, I would suggest, what the FTT has got in mind at 119. Although, and perhaps not surprisingly, as it was 10 years before the meeting, Mr. Crucial could not recall the details of the board meeting, but said he hadn't taken account of any UK tax advantage in making the decision to proceed with the transaction. Minutes of the meeting confirmed that Mr. Fleming advised that such an approach should be taken. Mr. Crucial believed he'd followed this advice, and the minutes do not record that any of the other board members had not done so. Also, Mr. Crucial said that he was comfortable with it and had not concerns over its commercial viability. The transaction would have proceeded, even if at the last minute the tax advantage has ceased to exist. Additionally, he confirmed that in making the decision to approve LLC 5, entering into the loans, he considered his fiduciary duty was satisfied. So that's 119. So, stopping there, my submission is that what the FTT has found, not as clearly as one might have hoped, but nevertheless it's found, on the basis of Mr. Crucial's evidence and the unchallenged board minutes, which record the advice that Mr. Fleming gave, that he and the other board members followed that advice in not taking any UK tax advantage into account, on the ground that the company itself would gain no benefit from it. Now then we go to 120. First sentence, Mr. Crucial did not go so far as Ms. Malinieu, who had no thought of warmth and decency when she bought her working clothes, and say that a tax advantage was not an object or purpose of LLC 5. Now, question is, what does that sentence mean? The Upper Tribunal thought what it meant was he was acknowledging that the purpose, the raison d'etre of LLC 5 was, that was why it was created, was to take part in this in order to get a tax advantage. So that's what he was saying there. Now, if I can go to what Mr. Crucial said at paragraph 40 of his witness statement, which is what the Upper Tribunal referred to as supporting this interpretation of that sentence. It's in the supplemental bundle at page 83. Could I go to that? This is Mr. Crucial's witness statement.
Well, paragraph 120, before we leave it, you'll know it by heart, but it's not referring to anything that Mr. Crucial's evidence said in evidence. It doesn't purport to be that. It's a comment.
No, it's comment.
It's a comment. Now you're going to take us to the statement.
Yeah. And the question is, what is meant by that comment?
Yes.
But I accept that it's not referring to something he said. So, paragraph 39 at the top of page 83, I've been asked to comment on what I understand to be the purpose of LLC5 generally, and also the purpose of the LLC5 board in approving the transactions presented to it on the 30th of November 2009. And then could I ask you to read paragraph 40?
Yes, I'm reading for the first time. Where does he tell us what the purpose of LLC5 generally was?
I think it's probably the first sentence.
Well, I mean, we know that it was there and that there was an acquisition, but what's the purpose of LLC5?
So he's trying to answer two questions which he says he's been asked.
Yes, but you could have had 2 LLCs or 12 LLCs. You could have as many LLCs as you want. What's the purpose of LLC5 from this evidence?
Well, to facilitate the acquisition of BGINA.
But it's not necessary to do so.
Well, I'm not saying it's necessary. I mean, there are various ways of skinning a cat, but they decided that LLC5 should be involved, and to do so in a way that was efficient from all perspectives, including tax. So
you come back to the same.
He's acknowledging that.
Well, this fits with. I mean, I can't remember what the exact expression was, but when he was asked about that, he wasn't able to provide any other reason.
No, he wasn't. And that's
because I mean, the oddity of it is that it's situated here.
Yeah. It's a UK company, where everyone else is well, not everyone else is offshore, but the money is coming from the US and is going into the US.
Yes. So in a sense, it's a. I mean, he's asked himself the question, and then I might say he hasn't really answered it. At least not in a straightforward way.
Well, perhaps not in a straightforward way, but anyway, so far as it goes, I would suggest he's acknowledging that when one is asking what the corporate mission, or one might call the raison d'etre of LLC5, he's acknowledging that it had a role to play in the group, which included, and one might say, what else did it include, but included or consisting of doing something in a tax-efficient way. So he's acknowledging that, I would suggest, in paragraph 40. But then he's contrasting that, as I understand it, in paragraph 39, from the purpose of the LLC5 board in approving the transaction. So he's acknowledging, I know why this company was created. Now I'm going to tell you about what my and the other members of the board's thinking was in our decision. So that's the contrast he's making. And again, one might well have suggested, let's put the two together, Mr. Kuchel, in reality. But that wasn't the point that was made below, before the FTT. Anyway, that's 40. And then if one goes on to, can I ask you to read 41 and 42, please?
So that takes us back to the FTT
Right.
drafting.
So then the question is, is it right, as the Upper Tribunal thought, that that's what Mr. Kuchel was or rather the FTT was talking about in the first sentence of 120, that he didn't go so far as Ms. Maladieu and say that a tax advantage was not an object or purpose of LLC 5. Now, the only difficulty with that is, why is the FTT looking now at the raison d'etre of LLC 5 when it said at the end of 117 it's necessary to ascertain the subjective intention and purpose of LLC 5's directors, and at 119 it said, it's recorded in my submission, that Mr. Kuchel and the others left tax out of account when they made their decision. Why has it gone on at 120 to say what that first sentence says? Now, my submission is that something's gone wrong with that sentence. What the FTT was really trying to say was, Mr. Kuchel didn't go as far as Ms. Maladieu and say that he had no thought of tax, but said that a tax advantage was not an object or purpose of LLC 5. Now, I'm reading words in there, but that's the contrast which I would submit Mr. Kuchel is making. He's saying, yes, I acknowledge that we thought about tax, we were told about tax. The board minutes mentioned that there was a tax advantage. So yes, in that sense, I was unlike Ms. Maladieu, who consciously didn't think about warmth and decency at all. We did think about it, but it was not one of our purposes. And if that is the correct interpretation, that makes sense, because that then ties in with the next sentence. However is suggesting I'm now going to move away from the conscious subjective purposes of Mr. Kuchel and the other board members, and I'm now moving on to something else, which is Maladieu and Drummond. It's necessary to look beyond the conscious motives of LLC 5. So when he says LLC 5, he means the directors of LLC 5. And I would suggest that's also in the first sentence, when he says, was not an object or purpose of LLC 5. He's still referring to the directors of LLC 5 as whose purposes are attributed to it. So the first sentence, he's saying something about a contrast with Miss Maladieu, that although tax was in their mind, it wasn't one of their purposes, subjective purposes, conscious purposes. But then he says, however, we've got to go beyond their conscious subjective purposes and apply Maladieu and Drummond. In any event, I would submit, even the Upper Tribunal did not suggest that that first sentence was somehow a finding of fact about the conscious subjective purposes of the LLC 5 board. The Upper Tribunal thought that was a reference to Mr. Kuchel talking about the raison d'etre of LLC 5, as mentioned at paragraph 40. So, 120, having regard to all the circumstances of the case, it's in my judgment clear the securing of a tax advantage is an inevitable and inextricable consequence of the loan. And I would submit that it's an inappropriate point to be discussing outside of the sort of Maladieu and Drummond type context. It's not relevant that the legislation tells you that if you borrow money, you get a tax deduction for the interest. That sort of inevitable consequence is not the sort of Maladieu and Drummond type one. And then 121, this cannot be described as merely incidental, and as such is clearly an important purpose, so much I consider to be a main purpose. Then, okay, so that in my submission is the findings of the conscious subjective purposes of the LLC 5 directors, which the FTT has said it's necessary to ascertain, at 117 this was, given in order to identify the purposes of the company. Then in terms of commercial purposes, as I've mentioned, this is an area which HMRC did challenge on Edwards and Bairstow grounds. It was rejected by the Upper Tribunal. But I can just say something about it. First of all, 121. However, the evidence is that LLC5 entered into the loans in the furtherance of the commercial purpose of its business of making and managing passive investments. That too is clearly an important purpose. And then 122, having come to the conclusion there was a commercial and a tax purpose, but focusing on commercial. So clearly the FTT has decided, on the basis of the evidence, that there was a subjective commercial purpose on the part of LLC5's directors. And if we ask what was the evidence then that the FTT is referring to at paragraph 121, in my submission it's got to be the board minutes and the evidence of Mr. Kuchel. And because we've seen at 118, it says in this regard there is the contemporaneous documentary evidence in the board minutes and the evidence of Mr. Kuchel. So if we start with the board minutes, the question is whether the FTT was entitled to reach a conclusion of fact about the commercial purposes of the directors, or the directors having a commercial purpose, based on the board minutes and Mr. Kuchel's evidence. And I submit, as the Upper Tribunal found, it was certainly entitled to. I mean, again, one might have reached a different conclusion oneself, but the Edwards and Bairstow challenge failed, and my submission should fail. So if we start with the board minutes, these are at tab 17 of the supplementary bundle. As I say, HMRC accept these as an accurate record of what happened at the meeting. Paragraph 3, this is on page 318. We see Mr. Fleming being invited to give an overview and an outline of the company's role. Mr. Fleming advised that although the incorporation of the company and the proposed transactions form part of a wider arrangements to effect the acquisition in a tax-efficient manner, they were nevertheless a commercially valid transaction for the company on the standalone basis. So that's his advice, that this is a commercially valid transaction. First point. And then if we go to page 319, and the third paragraph, so there's a reference there to various information which E and Y had determined. Then a third of the way down that third paragraph, these were reviewed extensively by the board to ensure that, at the level of debt to be incurred, the transaction was appropriate and commercial for the company. And then it was noted, it was noted that the company itself would gain no benefit from UK tax reduction for the interest since it was group policy and so on. It was necessary for the transaction to be considered by the board as viable for the company without taking any UK tax advantage into account. But in terms of the commerciality point, it was to ensure that the transaction was appropriate and commercial for the company. And then the penultimate paragraph discusses a short-term loan, tranche 1, how that was going to be paid. And then the final paragraph, the board then considered the Duff and Phelps analysis. And remember, I mentioned that to you this morning, of the relative values of the common shares and preference shares, which was based on a cash flow model, estimated discount rates applied to anticipated dividends, and a discount applied to the preference shares for lack of voting control. It was considered, and then over the page, that the price to be paid by the company for the LLC 6 shares was appropriate. And then, so that's really what's it in the board minutes. And then if I can take you to Mr. Kuchel's witness statement in tab 3 of this bundle, and what he says about it. Paragraph 24. Perhaps I could ask you to read paragraph 24. And then please paragraph 35. And then, sorry, finally, paragraph 37, please. And then I've already taken you to paragraph 41 in his witness statement, where he said it was necessary for the LLC board, board to satisfy itself that both the proposed investment in LLC 6 and the means of financing it, the loan notes, represented a good deal for LLC 5 as an individual entity. Having satisfied myself that the proposed investment was in the commercial interest of LLC 5, and so on. So that, again, he's giving evidence about it being in the commercial interest of LLC 5. Now that was the evidence which the FTT based its decision on. That was challenged in the Upper Tribunal. The Upper Tribunal rejected that Edwards and Bairstow challenge at paragraphs 137 to 152. And as I say, HMRC maintain their Edwards and Bairstow appeal on that point. So my submission is that if you've got, as you have got, it's common ground that we're looking at the purposes of the company, first point. Second point, that the FTT decided that given that the company was a legal fiction, the purposes of the company were those of its directors who hadn't been instructed and so on. Neither of those was challenged as errors of law. You've next got the findings of fact of the FTT, that in terms of the conscious subjective purposes of the members of the board in reaching their decision, they had a commercial purpose and they did not have a conscious tax purpose. But they did have a Mallory and Drummond, as it were, deemed purpose based on inevitable consequences, which in my submission was wrong in law.
Yes, I mean, in fact, the way you put it, they satisfied themselves that they had a commercial purpose. And they consciously satisfied themselves that they didn't have a tax purpose.
Well, I think it goes a bit further than that, because they...
No, but I mean, just describing what those minutes tell us. They consciously satisfied themselves that they were not considering tax purpose.
They consciously put tax and the tax advantage out of their minds when they decided whether or not they should approve the proposal that the company enter into these transactions. Now, then I come on to what the Upper Tribunal said about the tax purposes of the company.
Are we now moving
to the Upper Tribunal?
To the UT?
Yes, we are. Thank you. Now, can I start at paragraph 128, which is on page 119, where the Upper Tribunal refer to the Travel Document Service case. And they underline it was the company's subjective purposes that mattered, near the bottom of the page. And then, can I just, I know I'm jumping around, but can I ask you to go to paragraph 191? Paragraph 191, halfway down, there's another reference to travel document service. TDS confirms that the question of whether there's a tax avoidance main purpose is primarily to be decided by reference to the subjective intentions of the directors of the company. So that what the Upper Tribunal is doing is focusing on the company's subjective purposes that matter, and saying that primarily you look at the purposes of the directors in determining what the company's purposes are, but clearly not exclusively. And we'll see how the tribunal reaches that conclusion in a moment. So if I can go to first of all, under the heading Unallowable Tax Advantage Purpose, at below paragraph 152, and then if you go all the way to 161,
Sorry, the first one is 152, is it?
well, it's below 152. It's the heading Unallowable Tax Advantage Purpose.
Yes, I see. Thank you.
And the first, you see A, submissions on inevitable and inexorable consequences. So that's a discussion now about Malinu and Drummond. And that goes all the way to 161. We consider that the FTT misapplied the test in Malinu to the situation before it, that it should have relied on the principles derived from TDS, the only authority on this legislative wording. The FTT should have considered LLC 5's main purposes in relation to the loans from all the evidence before it, rather than apparently focusing solely on the inevitable and inextricable consequences of entering into the loans. So, stopping there, the Upper Tribunal has not been invited to move away from LLC 5's purposes, to pick up Lord Justice Nugee's point. And I say not invited to, nor did it do so. It's focusing throughout on LLC 5's own purposes in asking whether 441 and 442 apply. HMRC have never suggested that's the wrong test. But then 162, nevertheless, we're not satisfied there was any material error in the FTT's finding that LLC 5 also held a tax advantage main purpose in relation to the loans. So, just stopping there, although what it said is the FTT was wrong in applying Malinu and Drummond to decide that there was a subjective tax purpose, nevertheless, the FTT was entitled. There was no material error in that decision, because then it says the FTT was entitled to look beyond the stated motives of LLC's board members when determining the purposes of LLC 5 in entering into the loans. So we're still focusing on the purposes of LLC 5, but we can look beyond the stated motives of the board members. Now, when it says stated, I must admit, when I read this, and the word stated appears not only in 162, but 165 and 166 as well. It talks about the stated purposes and the stated motives. When I read that at first, I thought that the Upper Tribunal was saying what they say their purposes were, what they state to be their purposes. And of course, no one could object to saying the FTT was entitled to look beyond what they state their purposes were. You've got to question whether that was actually their purposes. But that isn't what the Upper Tribunal means, because it has already recorded that the FTT accepted the evidence of Mr. Kuchel and that the board minutes were not challenged and so on. So by stated, it doesn't mean asserted by the witness or by the board minutes. What the Upper Tribunal means is stated, found by the FTT. So in other words, what is being said, the second sentence of 162, the FTT was entitled to look beyond its own findings of the board members' subjective purposes. So in other words, you're focusing on the purposes of the company, but you can attribute to the company purposes of someone other than the board members. That is what the Upper Tribunal is saying here. So 163, there are two important matters to bear in mind. Mr. Kuchel accepted that tax efficiencies were part of the purpose for the inclusion of LLC 5 in the transaction. And then there's a reference said to be a similar finding. Second, it's undisputed that the board members were specifically advised to put any tax advantage out of their minds. As a result of this advice, the stated subjective intentions of the only director to give evidence were circumscribed and cannot represent the nature of the director's intentions had they been left freely and willingly to decide the main purposes of the transaction. And then if we go to 165, therefore it's necessary to look beyond the director's stated intentions. Just stopping there, what is being said there is the justification for looking beyond the intentions that the FTT has found is that they were advised to put tax out of their minds, and as a result of this advice, their intentions were circumscribed, or the intentions of the only director to give evidence. I don't know why it said the only director to give evidence, because that's true, but the FTT made findings about what the other board members thought as well, based upon the fact that the board minutes didn't suggest that they didn't follow the advice. But in any event, it's that they were circumscribed, cannot represent their intentions had they been left freely and willingly to decide. Now, I would respectfully submit that is erroneous, because merely because you've been given advice and you follow that advice, if it's not an instruction, the advice cannot sensibly, this is a proposition of law advanced by the Upper Tribunal rather than, nuanced fact-finding by the FTT, cannot be regarded as circumscribing the intentions of the directors. To say that they're not left freely to decide suggests that they were being told what to do. But there's no finding, there's no evidence of that. The evidence is to the contrary, expressly, that they were not puppets, they were not bypassed, that all they were given was advice. The Upper Tribunal says it's advice. So I would suggest you cannot move away in identifying the subjective purposes of the company from those of its board merely because the board is given advice. And then 165, therefore it's necessary to look beyond the director's stated intentions. The effectiveness of anti-avoidance legislation cannot be undermined by tax advisors telling parties to ignore the tax advantage purposes of a transaction, which has been planned by them or others for precisely that purpose. The hold otherwise would provide an easy way around the legislation. So this is moving on to a slightly different point, not so much that they're circumscribed and not free. It's a sort of purposive interpretation point, that if you decide to leave something out of account genuinely, you think about it but then decide to leave it out of account, it's not any longer appropriate to attribute your subjective purposes to the company, because that would undermine the legislation. Now, my submission about that is not justified as a matter of purposive interpretation, that the answer to that problem is one needs to challenge the witnesses in cross-examination and make a robust submission to the fact-finding tribunal and trust the findings of fact by the tribunal, and not say that because the fact-finding tribunal has made certain findings of fact which you don't like, that undermines the legislation. So that, in my submission, is really, in reality, what the Upper Tribunal was doing. It didn't like the findings of fact, and it said that this was undermining the legislation.
It agreed on the tax purpose.
I beg your pardon?
It agreed on the tax purpose, but it's just it didn't agree with the way that the First Tribunal got there.
Yeah. Well, yes, but
It wasn't that it didn't like the finding, it didn't like the reasoning.
no, it didn't like the finding, I would submit, didn't like the finding that it wasn't part of their conscious subjective purposes, and it didn't like the reasoning based on Mallew and Drummond, but then it jumps away from looking at the subjective purposes of the directors and says, we move beyond those. Now, the question is, what's the justification for moving beyond, looking beyond the subjective purposes of the directors in identifying the subjective purposes of the company? In my submission, there's none unless the directors are not the true decision makers. But that isn't the finding. So there's no justification for saying that you're undermining the legislation if you follow through what the legislation implicitly requires is looking at the purpose of the company, and that must mean the purposes of the board.
It seems to me it must be relevant to that, or maybe it's no more than relevant to understanding the FTT's decision, that there was a group practice of not charging for surrenders of group relief, which, and maybe this is what you would say underpins the FTT's decision, made it commercially understandable that the directors would need to consider whether the transaction was viable, at least, for LLC 5 without the tax benefit.
Yes, my submission is...
Put it in another way.
Yeah.
If that was not the group practice,
Yeah.
and LLC 5 was going to benefit directly from the tax losses, then the come off it, get real points gain a lot of strength.
Well, not just a lot of
strength.
strength in my submission. I would respectfully accept everything you say, but it goes slightly further than that, because if the directors say, we know there's a tax advantage for us, we're going to leave it out of account. Why? Because if we take it into account, we're liable not to get the deduction. That is a very dodgy line of reasoning in my submission, because it means that you haven't really left it out of account. It's directly your purpose of allegedly leaving out of account so that you get the deduction.
Well,
that would be...
maybe that's... You can understand the UT's point at 165 in that context.
Absolutely.
Clearly, if you're doing something
right.
with a view to getting the tax benefit,
Yeah.
and you just tell yourself
that you're not doing that.
I'm not doing that. That's
But I was going to, yes, thank you very much. But I was going to suggest that in making that point, the Upper Tribunal has overlooked the good, rational reason for the directors having left tax out of account. It wasn't so they could get a deduction. It wasn't an artificial line of reasoning. It was a perfectly explicable line of reasoning that it made no difference to the company, and we're going to focus on the commercial benefits to the company. Now, there's nothing wrong, I would submit, in focusing on the commercial benefits to the company and not of the group as a whole. That would be it's not an improper thing for directors to do. Conversely, of course, they can take account of the group benefit as a whole. But it's not an irrational thing to do, to say, we're going to look at whether this is in the best interest of the company. That's what they did, and that is reasonably, I would submit, why they left tax out of account. So that you're not undermining the legislation or sort of calling black-white by saying that in those circumstances, if it's genuine, if you've genuinely done that, then that is the result. And the FTT found that they'd genuinely done so and concluded that they had left tax out of account. And so it's a combination of points, effectively. Why do they leave it out of account? How come that their evidence was accepted? I've made my submissions on that. And then, paragraph 166, we therefore conclude the FTT was entitled to look beyond the stated motives or intentions of the board members to determine LLC 5's actual subjective purpose. This is supported by the approach in Travel Document Service, where it's apparent that Lord Justice Nugee was prepared to infer a different purpose for Mr. Turner using the shares in the swap than he stated in his evidence to be his subjective intention for continuing to hold the shares. Well, he stated in his evidence that was so, But it was found that he and therefore the company, because that case was focusing on the purposes of the company, did have a tax purpose for using the shares and therefore for holding the shares. So actually, Travel Document Service doesn't support moving away from the subjective purposes of the board. Travel Document Service was all about what were the purposes of the board. And that's why, I haven't taken you to this, but Mr. Peacock in the Court of Appeals said, once Mr. Turner left the witness box, not having been expressly challenged, what you said isn't true, that was the end of the case. Now, if everyone was saying, well, what the directors thought isn't the be-all and end-all, that would be a non-point. But the Court of Appeal addressed that point by saying, no, it was perfectly clear that his evidence was being challenged about what were his subjective purposes. And although he said the purposes were commercial, he was focusing on a different question, which is why we owned the shares rather than why we were using them. So the case was all about the director's purposes. It doesn't support the proposition that at some stage you can move away from the director's subjective purposes in order to identify the company's purposes. And then, if we go on to 168, the FTT was entitled to examine all the evidence, all the circumstances, when deciding LLC 5's purposes. This included the evidence leading up to the creation and registration of LLC 5. And then there's a whole lot of evidence and findings which is all about, not about the purposes of the directors, but about the purposes of the creation of LLC 5 and so on. And my submission is that the Upper Tribunal went wrong in moving away from the directors' purposes to other group purposes to identify what LLC 5's purposes were. So for example, 170, the FTT made findings that LLC 5 had been included in the acquisition structure for tax planning purposes. The question is, if you are focusing on the company's purposes, that's what everyone has been doing, that may cast light on it, why the company was created, but it isn't actually the test of the company's purposes to answer why was the company created. That the company's purposes is subjective, are the purposes of the board. That's my submission. I didn't. If we go back to 165, there's one point that I missed in 165 when the UT said the effectiveness of anti-avoidance legislation cannot be undermined by tax advisors telling parties to ignore the tax advantage purposes. And I just wanted to make the point that telling them to do so sounds like an instruction, but we know that there wasn't an instruction, that it was advice, and that was the finding. So then, finally, can I make very brief submissions on another aspect of this legislation, which is what happens if you decide there is an unallowable purpose. And if we go back to the authorities bundle, we're in tab 2. No, we're not. We're in. So we're looking at. I apologise. I've taken it out.
Which is the case?
It's section 441.
Page
Right.
19 is tab 2.
Yeah, thanks.
Thank you.
So it's subsection 3. The company may not bring into account so much of any debit in respect to that relationship as on a just and reasonable apportionment is attributable to the unallowable purpose. And that's subsection 1 if the company does have an unallowable purpose. Now, if you've decided that whether the company has an unallowable purpose is to do with the company's purposes, and indeed the director's purposes, their subjective purposes, my submission is in asking to what extent is the debit, the interest, attributable to that purpose, then you are still asking a question about that subjective purpose. It's simply a causal question, which is, to what extent has that bad purpose given rise to, attributable, it's a causal question in my submission, to what extent is the debit caused by that purpose? Now, clearly, in an obvious case where there's only one purpose, which is an unallowable purpose, then you would simply say, well, all of it is. If you've got two purposes, a tax purpose and a commercial purpose, then you need to decide to what extent the interest is attributable to those purposes. In a case where, in travel document service, there was an argument about that because the taxpayer said that even without the tax purpose, we would still have had the debit. And there was no evidence of that. There was no evidence to support that. But it was to do with a causal question. And I would submit it, whether it's attributable to or not, can be answered by, if you would have got the debit, all of the debit anyway, in other words, the debit has not been increased by the tax purpose, you would have got all of the debit because of your commercial purpose, then you cannot say that any part of the debit is attributable to the purpose. But we are still looking at the causal effect of the subjective purposes that we're interested in, because we've decided what unallowable purpose means. It's to do with the purposes of the company. Now, what the Upper Tribunal decided is, once you've decided that you've got, in this case, a commercial purpose and a tax purpose, you're no longer interested in those subjective purposes. You're now asking a very different question in section 441, which is an objective question of why, for example, was the company created? Now, in my submission, that can't be right. If you've decided properly that you're only interested in the subjective purposes, the commercial and tax subjective purposes, then all you're asking is what causal effect those subjective purposes had. You don't move away from that to ask a totally different question, which section 442 wasn't interested in, which is other people's purposes.
I'm not following this, because surely 4413 points one towards consequences. I mean, I understood that at an earlier stage in the argument, you resist consequences, as it were, being the test, but here surely consequences are the test, aren't they? Because it's attributability. Attributability,
yes, I accept that you're looking at, I've put it in terms of causal effect, but yes, you can put it in terms of a consequence of.
But that is just an objective thing, isn't it?
Well, it's objective in terms of whether something's a cause of something. But what I'm submitting is that the purposes that you're interested in is still the subjective purposes, because you're asking to what extent the unallowable purpose.
Well, you've ended up by a process of reasoning. In this case, on this hypothesis, I understand you don't want to be on this hypothesis, but on this hypothesis you've got two purposes.
Yeah.
And the tribunal then has to decide the extent to which the loan is attributable to one or the other.
Yes, but what the Upper Tribunal said is, when you're asking that question, you're no longer interested in the subjective purposes of the company.
Well, at the moment, I'm just, as a matter of logic, wondering why that's, when we've left subjective purposes behind by the time we've got to the point where there are some purposes.
Right.
I mean, the fact that the directors may wish something to be more or less attributable to something.
No, I'm not suggesting that their wishes or purposes are relevant to themselves to what's attributable.
So the just and reasonable is obviously an objective test.
Yes.
But you're trying to say that what you're attributing the tree is to subjective purposes.
Yes, you haven't moved away from those purposes in asking to what extent is the debit attributable to
But
them.
once you've got to the point where you've found the purposes,
Yeah.
it doesn't matter whether they're subjective, objective, or
No,
something
fair
completely
enough,
different.
but-
They're purposes.
No, okay, fair enough. But what the Upper Tribunal said is those purposes are not the purposes that I'm interested in asking whether the debit is attributable to the purposes. I'm now actually asking a different question, which is the purposes of the creation of the company. Can I just take
Yes,
you to
sir.
what the Upper Tribunal said?
So from 183.
191.
191, thank you. I see, yes.
So it really is, perhaps I can pick it up in the middle. Travel Document Service confirms the question of whether there is a tax avoidance main purpose is primarily to be decided by reference to the subjective intentions of the directors of the company. However, once such a purpose has been identified, the legislation simply requires there to be a just and reasonable apportionment. This test is to be applied objectively. The FTT erred by applying a subjective test. Now we'll just read on. What the FTT didn't say, because Mr. Cushell thought they would have done it anyway, therefore that is the answer. Read on, 192. If, as appears to be found by the FTT, a wholly subjective approach were to be applied, it would enable a company to avoid the application of the unallowable purpose rules by simply relying on its stated purpose of entering into the loans, or indeed whether it will be able to halt the transaction at a late stage. Mr. Cushell's evidence that the transaction would have proceeded even if the tax benefits had fallen away at the last minute does not, however, indicate the existence of an additional commercial purpose. While the group had considered whether the structure could be unwound if the tax benefits failed to materialise, as a practical matter, pulling out of the transaction at such a late stage was impossible in those circumstances. As Mr. Cushell had stated in cross-examination, the acquisition was a fairly complicated exercise, and so on. If I can jump to 194, we agree with Mr. Hewitt that the creation and insertion of LLC 5 into the acquisition structure and the loans approved by its board members, which gave rise to deductions, would not have been incurred but for the tax purpose. And then 195, despite the FTT saying it was applying the approach outlined in Oxford Instruments, if it had done so, it would have asked the question, would the loans, and therefore the debits, have existed at all if the benefit of the tax relief had never existed? The answer to that question is objectively no. There would have been no LLC 5, and no loans if the UK had not provided tax relief for interest in those circumstances. So what the Upper Tribunal is saying in my submission is, we're no longer interested in evaluating the causal effect of the purposes, the subjective purposes which the tribunal has found, whether you would have borrowed anyway, even without the subjective, well, it doesn't matter whether it's subjective, the found tax purpose because of the commercial purpose. It's now asking a very different question, which is, well, would the company have existed at all? Now, in other words, my submission is that's an error of law because there's no indication at all that Section 441 has moved away from being interested in the purposes that gave rise to there being an unallowable purpose in the first place. Moved away from that test of looking at what are the purposes of the company to now asking a completely different question, which is why did the company exist in the first place?
Yes.
So my submission is that the Upper Tribunal erred in saying that the FTT had gone wrong in asking the question, would the loans have existed because of the commercial purpose, even in the absence of the tax purpose? And they said, well, it would have existed anyway, and therefore none of the debits is attributable to that tax purpose. The Upper Tribunal has gone wrong by saying, let's not ask that question at all. Let's just ask whether the company would have existed anyway. And that's not what Section 441 is interested in. Now, maybe that's a good time to stop.
Not if there's more to say. I mean, would you like to, as it were, reserve yourself a
Well-
few minutes in the morning if there are things that you feel you
Well,
really
yes.
want to?
What I was going to do, if
Right.
I may, I meant stop for the evening. a good opportunity for us all. Is that in the morning, if that's all right, and that means we won't be overrunning for about 10 minutes. Mr. Yates is going to give our submissions on how the apportionment provisions should actually operate in this case.
Yes. Well, I'm sure Mr. Stewart won't mind that. And let's meet again at 10:30 and take that up. Thank you very much indeed.
Hi guys.